it's going to be really hard to hold your employer liable for not giving you something that you never asked for in the first place. One of the oldest tricks in the book is when an employer talks an employee out of applying for a job that the employee is perfectly qualified for. And they'll give you all kinds of reasons why you shouldn't apply. What they're doing is avoiding a paper trail, avoiding liability, and in many instances, protecting their favorites. So that if you ever try to file a lawsuit based on failure to promote, they'll say you never applied in the first place. I'm Regina Molden. I am an employee rights attorney, and in this video, we'll talk about discrimination claims based on failure to promote. What are they? What do you have to prove? We'll talk about some of the common ways that employers avoid liability and talk you out of applying in the first place. And then finally, we'll talk about what you can do if you find yourself in this situation. So let's get started. There are a number of claims that people bring, discrimination claims that people bring based on a number of different reasons. And one of those reasons, which we're talking about today, is failure to promote. So a lot of times supervisors have their favorites, and sometimes it's not based on race, sometimes it is. And sometimes it might be based on gender or not. But if it's their failure to promote you is based on a protected class. In other words, they are refusing to promote you because you're a woman, you're over 40, your race, and whatever that race might be. People think it's only people of color. It's whatever race. If they are refusing to promote you based on whatever race you are, then you possibly could bring a discrimination claim. If they're doing it based on your religion, whatever protected class, then you might very well have a solid failure to promote claim. But they're really hard to prove. And let me tell you why. So for every claim that you bring, you're going to have certain things that you have to prove. And for failure to promote claims, discrimination based on an employer's failure to promote, you'll have to show, number one, that you're qualified for the position. And most people don't have a hard time satisfying that element. Are you qualified for it? So you can check that box, probably no problem. And then the second one you'll have to show is that the position was open. Again, easy enough to show that. Either is posted or not. So that one's not too hard. But here, when we get to the third reason, this is where we start running into trouble. The third thing you'll have to show is either that you applied for the position and you were rejected, or that they talked you out of applying. Now, the one we're talking about today is where people get into trouble because it is so incredibly hard to prove. It seems like not a big deal, but it is. So whereas if you apply for it and you were rejected, that either is or it isn't. And so that's very easy to show. If you apply for it and they reject you, either there's some written communication or there's something to evidence, even if it's just your testimony, there's evidence to show that you applied for the job. And so that part is not hard, but where it gets tricky is when you have to prove that they talked you out of applying. And it happens all the time. I understand that. But you're gonna have to show that you would have applied if they hadn't talked you out of it. And so what they'll say is, I really didn't know you were actually you really wanted to apply. Or you really wanted the job. They come up, oh my gosh, let me tell you something. I had a case where my client was such a great employee. He'd been with the company for a really long time. And they let him get to a certain level, like team lead position, but they would not let him go much further. And he would apply for oh my gosh, he applied for all these jobs. And his supervisor, who just hated him, it was a race discrimination claim, would always talk him out of it. Oh, just wait. You're not quite ready for it. You need a little more training. Meanwhile, they're steadily hiring people that were less qualified than him, which gets to the next requirement, that you show that the person who actually got the job is outside of your protected class, and they were less qualified than you. Now, in this instance, my client, they strung him along for so long that the statute of limitations ran on lots of his claims, because You have an individual claim for each promotion that you were denied. And so he had so many, but again, so much time had passed that a lot of them, there's nothing he could do anything about because he waited too long. But in any event, you have to show that they talked you out of it. And you can imagine all the stuff they can come up with. It's your word against theirs. They can say, oh, I didn't understand. Yeah, you talked to me about it, but I didn't understand that you were ready to apply for it like now. I thought maybe that was some future aspiration. They can say whatever they want to say, but it makes it very hard. You can just do away with that by applying for it, showing I applied for it, you rejected me. Now let's get down to showing that you hired someone who was less qualified and who was outside of my protected class, which is the last step. After you satisfy each one of those elements, then you very well might prevail on your failure to promote claim. But again, those claims are not easy, because even when you get to that final step showing that they hired someone or promoted someone who was less qualified than you and outside of your protected class, then you have to show that they were actually less qualified than you. And that's kind of hard too. But at least you get to that place, because if you don't apply for the job at all, you don't even get to the next step. So make sure that you apply for the job. So needless to say, any job opening that you're qualified for, apply for it. I mean, you absolutely owe it to yourself to do that. Even if you think that they're probably going to reject you, even if they've told you they're going to reject you, apply anyway, because your applications and their written rejection are what those written rejections will serve as your receipts later on in court. So anyway, so if you see a job opening, again, apply for it, document that you've applied for it, keep any records to support the fact that you've applied for it, whether it's emails or scheduled interviews, whatever it is that you can keep to show that you actually applied for it, you do that. That's going to serve you well later on. And if they don't give you the job, then certainly you want to provide documentation that you were denied the promotion that you applied for. And then finally, you want to make sure that you find out who did get the job. Make sure they're outside of your protected class. Because, for example, if you're black and they gave it to another black person around your same age, that's not outside your protected class. So it's going to be hard to show that it's discrimination unless it's based on something else. But in any event, document the name of the person who actually got the job and write down all the details you can about that person. So again, we're going to assume they're outside of your protected class, otherwise you wouldn't have a discrimination claim. So, or unless it's retaliation, then I'll just say that's another thing. If you have been complaining already about discriminatory treatment and you think they're retaliating against you, then that could possibly help serve as a basis for a failure to promote claim. But anyway, discrimination based on failure to promote would require you to show this person's outside of your class and all the things that we mentioned earlier, that you're qualified for, the job was listed, and they hired someone outside of your protected class who was less qualified than you. So you want to make sure that you not only document what that person's physical characteristics are, that they are outside of your protected class, but anything you know about their qualifications. Sometimes, like I said, the cases are hard to prove, but sometimes not so much. Going back to the example of the client that I represented, my client was a stellar employee, was in a team lead position, but they were hiring people. Oh, and he had a 4-year degree, but they were hiring people off the streets with GEDs that my client would have to train, who then answer to them. So that was a case where we were able to win. But let me tell you something. This is just how hard these cases are to win. The lower court dismissed our case, saying that we didn't have enough evidence, which blew my mind. But they said we didn't have enough evidence to proceed to a jury. Didn't even let it go to a jury. And that happens, oh my gosh, so many times in employment cases. Anyway, we appealed it and went all the way up to the 11th Circuit, which is a very high-level court. It's just below the U.S. Supreme Court. And I argued that the judge got it wrong, and I was so excited because we got them reversed, and so they ended up having to pay my client a lot of money. But in any event, it took years, probably 6 years, to get that case to the place where we finally resolved it. But you can help a whole lot if you document everything. Be very detailed with your documentation in terms of who got the job, when it was listed, what did they say when they listed the job, because they are very bad about changing the qualifications so that they can make it okay for the actual person that they want to get the job. See that all the time. In any event, it's your documentation, that is your evidence, and that will take you a long way. So apply for those jobs.